My name is Vishnu Gopal TV. I am a legal intern at LEXIS and Company. I am from Cooperative School of Law, Kerala. I am a third year student pursuing BBA LLB Honors. So today's topic for this video is it's analyzing the Aruna Ramachandra Shanbaug versus Union of India. So the purpose of this video is to detailedly analyze regarding the judgment Aruna in the case Aruna Ramachandra Shanbaug versus Union of India. So, Aruna Ramachandra Shanbaug versus Union of India is one of the most renowned cases which urged for the need to change the euthanasia laws in India. The case discussed the constitutionality of passive euthanasia and had checked whether right to die will come under the meaning of this Article 21 of the Indian Constitution. The case also analyzed the question whether Section 309 of the IPC 1860 is penal in nature or not. The Honorable Division Bench of Supreme Court had comprising of the Justice Markandeya Kadju and Justice Gyan Sudha Mishra had delivered the renowned judgment of this case. Even though the judgment made in this case was overruled afterwards, this case, however, has its own significance. So just we can go through the brief fact of this case. So here in this case, the petition was filed by Miss Pinky Virani on behalf of the petitioner Aruna Ramachandra Shanbaug, who was a staff nurse working at King Edward Memorial Hospital, Parel, Mumbai, and she was attacked by a sweeper in the hospital in an evening on 27th November 1973, and she was attacked by the sweeper of the hospital who wrapped a dog chain around her neck and yanked her back with it. So the sweeper attempted to rape her, but she was menstruating at the time. So seeing that she was menstruating, he sodomized her and to immobilize her from doing this act, he twisted the chain around her neck. So on the next day morning, a cleaner found her laying unconscious in the floor with blood all over. So it is alleged that the supply of oxygen to the brain has stopped due to the strangulation of the dog chain, and the brain has got damaged. She was in permanent vegetative state, that is PVS, and she was still continuing in permanent vegetative state PVS for the last 37 years and was surviving on mashed food. So she couldn't move her hands and legs, and it was the KEM hospital staff who were treating her for the last 37 years. It was also alleged that there was no possibility of any improvement and she was completely dependent on the KEM hospital. The prayer of the petitioner here was to allow passive euthanasia for Aruna Ramachandra Shanbaug and let her die peacefully. So the issues that were raised here in this case were whether this passive euthanasia can be allowed for a person in permanent vegetative state, that is PVS. And the second issue that raised in this case was who is the appropriate surrogate of Aruna Ramachandra Shanbaug to decide whether the passive euthanasia should be allowed or not. So this judgment which came in this case was that the Honorable Division Bench here in this Supreme Court had comprising of the Justice Markandeya Kadju and Justice Gyan Sudha Mishra had delivered the renowned judgment of this case on March 7, 2011, and here the court held that Aruna Ramachandra Shanbaug is not brain dead. She is neither in coma stage also. So she is in permanent vegetative state. Though she is in permanent vegetative state, she is in a stable condition and she could breathe without help of anything. So she is able to take mashed food and a spoon of water directly through the mouth, and she is also responding to stimulus, and therefore terminating her life is clearly an unjustified thing. So the court also pointed out that the management of the staff of this KEM hospital is a really appropriate surrogate of Aruna Ramachandra Shanbaug, and Miss Pinky Virani is not an appropriate surrogate. So the right to take decision is vested with the management and staff of this KEM hospital because they have taken care of her for the last 37 years. So the court also appreciated the excellent nursing care which is being delivered by the staffs of these KEM hospitals. So here the life sustaining thing of this Aruna is the mashed food. So and removing the life sustained treatment here means to stop feeding her. So removing the ventilators and discontinuing the feeding cannot be considered as equal. So when passive euthanasia is allowed to Aruna, then all the excellent nursing care, treatment and efforts which has been taken by the KM hospital staffs and doctors will go drain. So passive euthanasia cannot be permitted for Aruna. So in a final judgment, the bench held that active euthanasia cannot be accepted because the law ethical levels which has been prevailing in our society, which will lead to the misuse of it. And that means the immoral persons will help of the with the help of these immoral doctors may fabricate material to show that it is irreversible case with no recovery chance. So the court however held that passive euthanasia should be legalized, and the power to decide regarding the passive euthanasia is not given to the family or doctors completely. Instead, the court stated that Article 226 gave power to the High Court to pass suitable order on the application filed by the close relatives or close friends or doctors or hospital staff for granting permission to this to withdraw the life support to an incompetent person of the kind above mentioned. So a bench of at least 2 judges must be formed and should decide whether to grant approval or not. So based upon the opinion of this committee of 3 approved doctors appointed by the court for this purpose. So here the court also made a recommendation to repeal section 309 of IPC. So in Aruna, Ramachandra, Shanbaug versus Union of India, here it is a landmark case which had made a procedure that should be followed for allowing passive euthanasia in case of an incompetent patient. So the question that still remain here have to be also looked on to. So here, although this case clarified that upon the circumstances and the steps to be followed for the approval of this passive euthanasia, the court didn't expressly mention about the point whether the right to die with dignity will come under this meaning of this Article 21, which provides the right to life and dignity, right to live with dignity. So the court also didn't give a suitable clarification regarding the matter that if a person is going through a terminal illness and if he is competent, whether he can decide regarding the termination of his life or not. And also the judgment also lacks clarity regarding the matter that whether right to live includes the concept of right to die with dignity without suffering unbearable pain during the medical treatment. Although the right to die has been added to the fundamental right after the landmark judgment in the case of Common Cause versus Union of India. So this Aruna Ramachandra Shanbaug versus Union of India is a landmark case because it permitted passive euthanasia to those patients in PVS under strict procedures. So that's all about my topic. So you can like, subscribe and comment on my video, and do like and subscribe our YouTube channel Lexcliq. Please give me a feedback on this video, and if you have any questions relating to this video, you may please comment that question in the comment box. I will be replying as soon as possible. So this video does not solicit any type of promotion or advertisement as per the guidelines of the Bar Council of India, and the sole purpose of this video is for educational purposes only. By saying these words, I'm concluding. Thank you.